Hello, everyone. We have been talking about wills in Georgia. With that, we have gotten more questions and thought about giving some examples that might help people. So this is what we're going to do today. I'm Raluca. As an attorney, I provide estate planning, immigration, and family law services. My marketing and office manager, Nina Clear, is here with me. Don't forget your interactions such as likes, shares, and comments help others to see our videos. And thank you for helping us to have as many people as possible to see our videos.
One thing people ask us is, do I have to have a will?
There is no law that requires you to have a will. If you don't want to have one, that is your prerogative.
So why do you recommend that people have one?
If you want specific people to have your belongings after you die or not have them, you will need to have a will. Let me give you an example. I had a client, their father died, and the wife, who was the stepmother, claimed that her husband wanted her to receive 100% of the estate. But because he died without a will, every child is entitled to a part of the estate. So if the father truly wanted the wife to get everything and the children to get nothing, he needed to write a will.
And then even if you want people to get more of something, but maybe not all, you need to list that out, right?
Right. If you die without a will, the law says that your spouse will get a certain amount and your child will get another amount. And if you do not have a will saying something different, that is what will happen.
Okay. And then we had a person who had some jewelry and they wanted their sibling to get it when they died, and everyone in the family knew about it. But since they died without a will, that couldn't happen, right?
Again, yes, that is correct. When the law requires a will to be written, anything you say won't be followed. So you need to have that in writing, regardless of how many people heard you say that or they agree with it. In Georgia, a person's spouse is the first and only heir. So if there are no children, and then there are the children, and so on from there. But yes, you do have to have your will in writing.
And what happens if there's no will and specific belongings were promised to someone who is one of the heirs? So, we said the siblings, and the siblings aren't an heir if there's a spouse, but say there's a spouse and children.
It really depends. When an estate is put in probate and the person died without a will, the value of the estate will be considered. When there is a dispute, you may be able to use alternative dispute resolution, such as mediation. At the mediation, the family could agree the estate is worth, for example, $100,000 and the ring is worth $5,000. So the person who gets it loses out on other parts of the estate. The agreement will be submitted to the probate judge and they approve or deny the agreement. If the parties cannot agree, what the person gets, say this specific piece of jewelry, the judge may order everything to be sold and each person gets a percentage of the money. So this could be especially sad, talking about this example, if there were items that had been in the family for generations.
Or even a lot of times when you sell jewelry, you don't get the full value,
True.
Maybe
yes.
Not just as an heirloom, but they only weigh a ring, they'll weigh the gold weight, and that's all that you get.
Yes.
So
yeah.
So you mentioned probate. Tell us what that is.
Probate is when someone dies and turns the will over to the probate court to ensure that it is followed. Or if someone dies without a will, the probate court will determine who gets what based on the laws of the state.
So probate applies if there is a will or not, just to make that clear.
Yes.
And even if there is a will, you have to go through probate.
Yes.
What about if someone before they die inherits money, but they didn't get the actual money, so they I know someone recently, they died, they had gotten like $15,000. They said to the person sending to them, send it to this other person for me. But then that was never done.
Never done.
Okay.
Yes. Again, if it isn't in writing, there is little that can be done. So if the person has money owed to them, any money owed to them now becomes part of the estate. This money has to be distributed based on the laws of the state in which the person died when they die without a will.
And so, any gift you give before you die, hold on one second, sorry. Is a gift that you'll, sorry.
That's maybe, okay.
So what about if someone gives a gift to someone before they died, and now the family is demanding that it be given back and considered part of the estate?
Well, any gift you give before you die is a gift you give, and unless it could be proven that you were not competent, so you didn't have the mental capacity to make a decision, or it was taken from you fraudulently, it would be almost impossible to reverse that, what happened. So
sorry, we got discombobulated because somebody came in. Sorry.
That's why this
Welcome
is
to our bloopers.
Yes.
So if you aren't going to write a will, give away everything before you die. That's what you're saying.
Well, yes, that would be one suggestion, although less than ideal solution. But then, do you know when you die? So
if you give everything away and then you live for 20 more years, you might be really sad. Okay. So what about if you're forced to sign a will? So somebody puts it in front of you and says, this is what you have to sign. Is it valid?
No, your will must be entered into without coercion or force in Georgia in order to be valid.
And can you leave your money and belongings to your dog or your cat because they were nicer and loved you more than any of your family?
They might have, but you cannot. You can leave it in a trust to be used for their care, or to an organization saying they inherit the money or belongings as long as they care for the animals, but animals cannot inherit in Georgia.
And what about if you received Medicaid before you died?
The state of Georgia is allowed to place a lien on your real or personal property if you received care at a hospital, long-term care facility, or mental institution before you die.
Can you explain what that means, a lien?
That means that they now have an interest in that property, and before anyone else can collect on it, whatever they say is owed must be paid in full before anyone else can collect.
So is that true even if you have a will?
Yes, it is. The only exception is if the estate is worth less than $25,000.
So does a person have to tell their attorney everything that makes up their estate for their will to be valid?
Well, let me put it this way. We heard of an attorney who had a client who wanted their will written. They had spent months getting information and value for every business, most belongings. He owned quite a few antiques and all of his properties. And when the papers were ready to be signed, it turned out that he also had a piece of art by a famous artist that hadn't been mentioned or even had been appraised. So because of the high value of this piece of art, now the will had to be redone.
And why is that? Did it invalidate the will?
The will wasn't invalid, but most attorneys in the estate planning field have seen that, and money does strange things to people. So it might be that his family didn't care if someone received that piece of art. As a general, everything in my home goes to this one person, but due to the value that was over $1 million, it might have started a big fight, and people would say that he didn't intend for one person to get that. Just as with other parts of my law practice, estate planning is only as effective as my clients are open and honest with me. When I know all of the parts of an estate and any that might cause contention, we will do our best to be sure it is handled so that no one can contest the inheritance. If I don't know, we cannot do very much to stop the fight. We hope we answered some of your questions. And please call us if you have other questions or write your comments here. And if there is something we didn't cover, please reach back to us. Thanks for watching and see you tomorrow.